invitation. Also, just a note that we're recording the session, so folks will get the recording as well. So if you like, as a way for a couple of minutes to possibly get oriented to your body, you're welcome to give yourself a moment, maybe beginning with some movement. And however you're oriented, maybe you're sitting in some way, maybe you're standing, however you're oriented in your body, invitation to add some movement on purpose. One way you might do that could be shifting from side to side. Maybe you're shifting your body from side to side. You might discover another way of moving for yourself. Maybe you're interested in moving part of your body, your hands, for example. The invitation may be to add some movement. And if you're starting to move in any way, you may begin to notice some sensation. It could be wherever your body is connected to a surface. So you might start to feel those contact points or connection points. Or maybe you feel sensation in your body, in your muscles, around the part of your body that you're moving, potentially. And you're welcome to stay with that if you've discovered something for yourself that you want to stay with there. If you want to try a couple of other possible movements, one could be some shoulder circles. So if you like, welcome to roll your shoulders. And that could be either forwards or backwards. So you have a choice about the direction. Maybe beginning to feel some sensation around your shoulders. You could do elbow circles, another option for moving around your shoulders, and that may be bending your arms and circling through your elbows. Could be another possibility. And again, maybe starting to feel some feeling around your shoulders. And you're welcome to stay here if you've discovered something for yourself here. One more option, if you like, could be some neck movement. And one way you might move your neck could be tilting from side to side. So one option, if you're interested in moving your neck, could be tilting your head from side to side. Another possibility could be more of a circle. If you drop your chin through the middle and roll across. So at least these two possibilities. And you're welcome to choose. Maybe beginning to feel some sensation around your neck if you're moving in any way. And whenever you're ready, maybe winding that short practice down, and that process of transitioning back to the meeting, you're in charge of that for yourself. You might want to stay with your body a little longer. or maybe you're ready to transition back. Your choice. Great. So welcome, everybody. Because trauma is fundamentally about people and power from our perspective, trauma intersects and engages with all parts of our lives. Trauma is personal, it's political, and it's public. Today, in our roundtable, we'll focus on some of the legal implications of trauma, how we as a society assign culpability, who is constrained, who is exonerated. To do this, we're honored to welcome three distinguished guests: Ellen Williams, Rebecca Epstein, and Talia Gonzalez. Ellen is legal director at Justice for Incarcerated Survivors Program in Georgia. Rebecca is executive director of the Center on Gender Justice and Opportunity at Georgetown Law in Washington, D.C. And Talia is senior scholar at the Center on Gender Justice and Opportunity at Georgetown and professor of law at the University of California in San Francisco. And we're grateful to have you all with us today to lead this conversation. I'll turn it over to you, Rebecca.
Thanks so much, Dave. I miss starting every meeting that way. I think if lawyers started every single meeting that way, the world might be a better place. But it's all too rare, right, Talia? Yeah. So thank you very much, Dave. If you could start, actually, let's wait to start the slideshow for just a second. I just wanted to thank you, Dave, for the invitation to present on our collective and collaborative work on criminalized survivors of gender-based violence and the related issue of adultification bias against Black girls in particular. The opportunity is wonderful for us because although I think all of us probably most often speak to a legal audience, trauma is such a through line of our work that it's important for us, and we have addressed this as an issue that affects women and girls at the Center on Gender Justice, at least, and how trauma affects their treatment in public systems, whether that's the justice system, the school system, the healthcare system, the child welfare system, etc. So we're going to, I think, my slides might be more dedicated toward girls because the mission of the Center on Gender Justice and Opportunity at Georgetown Law has its largest focus on girls because they're so often left out of the conversation when we talk about gender. But everything that I say will apply to those who identify as women as well, and really all survivors of gender-based violence. But we like to bring to the center sometimes the issue of girls so as not to leave them at the margins. So Dave, with that, if you could start on slide 2, that would be great. I'm just going to start by grounding us all in some background that I'm sure everyone here already knows, that women and girls experience significantly higher rates of sexual violence. And a cruel irony of that fact is that survivors aren't supported as victims of crime or the human rights violation that is gender-based violence, but instead they're treated as offenders themselves and sent into the justice system inappropriately in a way that can disproportionately affect women and girls due to their rates of sexual violence. Next slide, please. This is just a quick slide that gives you a statistic for girls in particular, that 1 in 9 girls in the US experience gender-based violence in this disproportionate way. In terms of an adverse childhood experience, sexual violence is disproportionately affected by girls. rather than boys. Next slide, please. We also want to reiterate that those high rates of sexual violence are all the more troubling because in addition to the trauma of the experience itself, of course, it also acts as a primary driver of involvement in the justice system for survivors. So I'm saying this twice because it's a difficult thing to absorb and accept that this is what is happening for gender-based violence survivors. Next slide. Just a quick infographic from one of the center's reports that was released in 2023, where we just list some of the paths that survivors take into the justice system because of how the system treats them, responds to them. We start in red with I would say the most pure form of criminalizing survivors in the worst sense of the term, in that the only action taken by the victim of sexual violence is to experience it. And when they report to police, they get criminalized for it. I'll be addressing that later. And Ellie will be addressing the issue on the other side of the spectrum, the more complex issue of when survivors take action in order to survive and escape their abusers. And I think I will hand this over to Ellie at this point rather than take up more of our time. It's a short amount of time. And I just want to make sure to get to Ellie and Talia. So Dave, if you could forward the slides. There you go. Take it away, Ellie.
Thanks so much, Rebecca. So I wanted to just share with you all a little bit, as kind of explained briefly. I am the legal director of the Justice for Incarcerated Survivors Program at the Georgia Coalition Against Domestic Violence. So I'm an attorney, and I kind of do like strategic leadership of the program, but I also am a direct practitioner. So my practice is focused on providing representation to survivors in criminal cases where their conviction is closely tied to the abuse. I'm mostly doing post-conviction work, so trying to help folks get out of prison or have their sentences reduced, get out on parole, conviction overturned, whatever we can do to reduce the criminalization. So through my practice, I've learned a lot of lessons that I'm happy to share with you, but also we do in my program policy work, and in looking at how the system responds to this issue, which I'll talk about a little bit more. We identified the need for significant legal change, which we were luckily able to successfully achieve this year. So you can go to the next slide. So it's just kind of a brief note. I think important context is how the criminalization of survivors really came to be in the United States. So this is somewhat oversimplified because I'm sure, there is a lot of sophisticated nuance to this issue and prior to the phenomenon I'm about to describe. But one thing that we know is strongly correlated is looking at general trends in our legal system's response to crime and to domestic violence. So in the 70s and 80s, as I know all of you know, we had the mass incarceration movement in our country, the war on drugs, and other significant increases in criminalization. Not much later, in the late 1980s and early 1990s, we passed the Violence Against Women Act. The Violence Against Women Act is a federal law that is really, one of its main purposes was designed to shift our thinking as a society about domestic violence. We were hearing, this is a private issue, this is a family problem, this belongs in your household, and the response belongs in your household. It's for you all to fix. But people started saying we treat random crime or crime against other people, or violence, random violence, violence against other people as a crime, and domestic violence should be treated similarly. Why do we not punish people or hold people accountable when it just so happens that the person they harmed is their partner? And we started to learn more about abuse and trauma, the dynamics of domestic violence, and how that's actually a particularly dangerous and challenging dynamic when the violence is happening between family members or romantic partners. So the effort to criminalize it was one of the goals of passing the Violence Against Women Act. Of course, the federal government can't tell states what to make their criminal laws, but they can say if you do these things or have these programs, we'll give you money. So federal funding incentives. So what we know is particularly women of color and members of the LGBTQIA plus community were saying at the time, this is going to go poorly for survivors when we take this broad approach to pushing criminalization. One of the consequences is going to be that the system is going to fail to understand what's really happening and survivors are going to be punished. And we know that that is what is happening. So when we look at where we are now, we know that back then we knew some things, and again, we didn't listen, we didn't heed some warnings, but that also since the late 80s and early 90s, we've learned a lot about domestic violence and trauma and its dynamics. So this change in this evolution in our understanding and related, not fix, but somewhat shift in our sociocultural view on these things, it's become much less acceptable in our society, though it's still too acceptable. It's better than it was 30 years ago. We know that we need to make sure the legal system can do a better job of accounting for it. And the system has not caught up with what we now know and how we now view domestic violence. And we can go to the next slide. So essentially, we look at survivors who are criminalized for acting to survive. I like to always note that I don't like to say a survivor whose crime is connected to domestic violence because we're also trying to assert that their actions shouldn't be treated as crimes or the law shouldn't define them as crimes when you're acting to protect yourself. And so that's why I say an individual whose conviction or criminal activity allegation of it is in some way connected to their abuse. And we'll talk in a moment about some specific ways that that looks. But essentially, we know that trauma affects survivors in a number of ways. They might perceive danger or threats of danger differently because of what they've experienced. Something that to a person who has experienced trauma might be meaningless, might be significantly meaningful, or indicative of a threat or danger to someone who's lived in an abusive situation. Survivors know how to interpret the behavior of their abusive partner. They live with this person often or spend a lot of time with them, and they know how to recognize patterns. They're living in survival mode, so they're always looking to sense what's going to happen next, how's he going to respond to this, and it affects their general perceptions of things in the world. So we know also that survivors make safety decisions that don't always make sense to the average person who hasn't experienced trauma. For example, I know that if I leave, or I think that if I leave or try to leave, he might significantly harm or kill me. Statistics actually show that that's accurate, that survivors are in extra critical danger. It's the most dangerous time in an abusive relationship when they try to leave. And he might have threatened to kill her if she leaves, who can look a lot of ways. But they might say, my child is actually safer if I stay in this household, because if I try to leave, he's going to kill me and or my child. Or if I leave and he kills me or harms me or whatever it might be, my child is left with this abusive person. So she might say staying in this household is safer. So there are a lot of things that we might not think make sense, but trauma really informs a survivor's behavior, their children's behavior, and their perception of the world. And again, in a way that the system often fails to account for and understand. So we can go to the next slide. So this plays out in a number of ways in which survivors end up being criminalized. So because of the way trauma affects the brain, a survivor might think that they are in imminent harm or in imminent harm's way, or that there's a threat of imminent harm to them by their abusive partner on the basis of their partner's behavior. And they might act accordingly, like to protect themselves against their partner with physical violence, which we would label as reactive violence, which is distinguishable from violence intended to perpetuate a cycle of power and control or to inflict harm. So we intended to inflict harm, to be clear. So what we know is survivors might hit their partner. They might scratch their partner to get them off of them if they're being strangled. They might shoot them. They might use a weapon to protect themselves, which can lead to the person who's the primary perpetrator of abuse being harmed or killed. We know that the system fails to account for how we got there. The system wants to know, did she pull the trigger? Did she hit him? The system does not typically ask the question of how did we get here and why did she do that? So when we look at these situations, what might have happened is that they were in an altercation. It subsided a little bit. And then she acted to protect herself. What's probably going through her brain is this is still an active threat. I know that this behavior of his indicates harm is coming to me soon. So I need to go ahead and act to protect myself. General self-defense statutes don't account for that. They're saying the threat had subsided. There was no imminent threat. So her action is just a violent crime or is just homicide, failing to account for the way the trauma and the experience might have informed her perspective or affected her perception of danger. And those effects are really neurobiological. It's chemical, and it really affects the brain in a very concrete way. So she might be criminalized for acting to protect herself against her abusive partner. Those same phenomena play out in the way she might perceive an instruction from her abusive partner. If he tells her to do something that is criminal, she might feel that she has no choice but to do that, or to face severe consequences and physical harm or danger by her abusive partner. She might use drugs to cope with the abuse that she's experienced. She might steal money. It's the only way she knows to obtain the resources she needs to leave and keep herself and her family safe. Like I described earlier, she might stay in the household and he might harm the child. That happens. But mom is often criminalized for failing to protect the child from the abusive partner, even when she didn't do anything to directly cause the harm. So we look at all these things and it's very complicated, and different, legal frameworks in different states make this more and less likely. But often the high level of it is that in all of these concrete ways a survivor can be criminalized, the underlying issue is that the way that the trauma affects her behavior, her perception, her responses, her state of mind is not adequately accounted for. And so I would label all of these things as acts of survival. This is the best way she knows to keep herself and her children, if she has them, safe. But the system doesn't account for the way that abuse plays out. And so what we end up doing is punishing and over harshly punishing survivors for surviving. And we can go to the next slide. So when we don't understand abuse trauma and its impacts, this leads to us having bias against survivors, as do other things like our general perceptions of gender, and gender-based violence survivors and all these other things. We then misconstrue what happened in the situation, and we misunderstand or misinterpret her behavior or apply beliefs to it that are inaccurate or unfair. And when we have this inadequate understanding, or we don't create adequate space in court for the correct understanding and our applied understanding of trauma to come in, what we do is we create harmful statutes. When we courts interpret statutes, we create harmful case law. We misapply laws that may or may not on their own be harmful, right? Sometimes courts make poor decisions, juries make poor decisions because we have this bias or this misunderstanding, even when the law itself isn't the problem. And then we punish survivors in legal ways too, but too harshly. Like when a judge has, for example, typically if someone gets convicted in court, the jury issues the conviction and then the judge decides how long their sentence is. Sometimes we have mandatory minimum sentencing laws or fixed sentences. Often there's a range. And what we see is judges might select the higher end of the range when they don't have to, or prosecutors overcharge. They're very harsh in the way they press charges against the survivor, again, in a way that they don't have to. And the root of all of that is our lack of understanding of abuse and trauma and the lack of space for it in the system. And we can go to the next slide. So our state essentially was looking at this problem and decided that our litigation and representing individual survivors was impactful, but that we're really going to be stuck fitting a square peg into a round hole when the system creates no space for asking these questions about how abuse played a role in what happened. So we created a new law called the Survivor Justice Act. And if anybody's interested in this in your state, I can tell you all kinds of details and stories about how we got here. But essentially what we did is we wanted to look at the entire span of the criminal prosecution process. How can we start at the beginning and prevent survivors from receiving these convictions to begin with? And then for those who do receive the convictions, whether their fact pattern doesn't quite fit one of our affirmative defenses, they don't have enough evidence, whatever it might be, we want to make sure we can still do what we can to mitigate the harm done by the system and their punishment. So we created a reduced sentencing scheme, which is also retroactive. So super high points about each of these. So on the front end, we looked at affirmative defenses. So you can say a lot of times our clients are in positions where it's not that they got the wrong person or they didn't do anything. It's I did fire the gun, but here's why. So we wanted to create more room for the here's why and here's how we got here. So we reformed our self-defense statute. So survivors now the courts can look at how would her state of mind have been affected by the abuse in assessing whether she was in imminent danger. And in situations of coercion, allowing again that same kind of question of how would the abuse have made her really believe this was necessary to protect herself committing this crime as he instructed her to. So that would allow juries to take this into account and maybe say, I'm going to say she's not guilty because I know all of this now. The reduced sentencing scheme asks the question much more broadly of, was she abused and was it a significant contributing factor to what happened? If the answer is yes, even if she's convicted, the judge has to give her a lesser sentence within a range that the statute writes. And we know a lot of survivors are already in prison and fell victim to our lack of understanding of abuse and our outdated understanding and application in the law. And so we wanted those folks to be able to get back into court and ask the court to look now in light of our updated understanding and again, creating space for that question to be asked and then have their sentences retroactively reduced. And we can go to the next slide. There's a lot of nuance to that. Oh, that's it. There we go. So that's mostly how we started conceptualizing the phenomena I described at the beginning and how we can start to equip the system to, again, ask that question. What is the context? What is the circumstance? How did we get here? And it creates a little bit of room for the gray. We know the system is very black and white. The human experience is not black and white. Trauma is not black and white. And obviously case by case is not efficient. So we can't have it just be the judge picks whatever they want anytime based on the facts. We have to have some framework, but within that framework, we were able to create a little bit more space to examine what happened to her that got her here, and is what's happening in the system appropriate and proportional to what happened given the complete context. So mainly it's just accounting for those dynamics of trauma and abuse. And again, I'm here, but happy to tell anybody more in detail about the law or our program. Welcome to reach out directly or in Q&A. So thank you. I'll kick it back to you, Rebecca.
Thank you, Ellie. And I just want to underscore, Ellie is maybe not singularly responsible, but she is one of the most critical players in getting really an unprecedented law passed in Georgia that will help survivors of gender-based violence in years to come in ways that the system had previously ignored them. And Georgia is at the forefront of this work in large part because of Ellie and her efforts. So I put this original slide back in the rotation to reorient you about these paths into the system. So Ellie just talked about what might be considered the most complex path for survivors into the system because of those dynamics in criminalizing survivors who fight back against abusers and traffickers. So just for a few minutes, I want to talk about the other end of the spectrum, as I mentioned, where sexual assault survivors go to police do not believe them, and police arrest them on that basis. So if we could have the next slide, please. So just starting with the very basics for non-lawyers, it is a federal and state offense to provide false information to police. Okay, there's a reason for that. And yet, when police don't understand trauma and they don't understand the symptomatology of sexual violence survivors that Ellie also referred to, such as self-blame, inconsistencies in how they describe the violence that happened to them, or a lack of remembering details and then remembering details later. All of you know these symptoms of trauma better than I do. But if police view these symptoms as evidence of lying, it can have profound consequences for victims of sexual assault. Police over and over again have been seen to be inaccurate in suspecting that survivors of gender-based violence are lying. And as a result, they are sent into the system when all they did was report to police. And I would note that this is especially true when for women and girls and LGBTQ individuals who report sexual assault. There's actually a case currently pending in the 10th Circuit where a survivor was a student in law school and was sexually assaulted during a party. She went to the hospital, told medical staff what happened. Police came, she told them as well. But she didn't want to press charges because she was a law student with a job offer at a law firm, and she was afraid to rock the boat by pressing charges. So here is a survivor who is doing nothing but getting treatment in a hospital. And despite that, or maybe even ironically, because she didn't press charges, the police investigated not the perpetrator of this violence, the alleged perpetrator, but the survivor herself, because they were so convinced she was lying. They went in and dug up her whole history, looked at her relationships with friends and others to heap blame on her. She was passed to the DA's office, who ultimately dismissed all charges with prejudice. So she eventually was released, but not before this extraordinary thing happened in which she had to endure an interrogation in the immediate aftermath of the sexual assault. Next slide, please. So the International Association of Chiefs of Police, the IACP, has basically recognized that this is not the way police should proceed. And they have issued guidance recommending against filing false reporting charges against people who report sexual assault. And despite that, especially women and girls, and I would say LGBTQ individuals, are particularly vulnerable to what scholars have called the credibility discount. There's a lot of ink that's been spilt on this, rightly so, to talk about how interviewers blame the victim. Characterological victim blaming of women and girls in particular who report sexual assault, despite knowing that, as I mentioned at the top of this presentation, that they experience a disproportionate level of sexual violence. So I wanted to give you a case study of this in addition to the 10th Circuit case that I just mentioned, where the center filed an amicus brief. Next slide, please. This is a study of an 18-year-old girl who reported being sexually assaulted at knife point. This is a horrible story. And rather than supporting her, rather than treating her as a victim of a crime, as they would other victims of crime, they attacked her because they found inconsistencies in her story that were pretty minor. Even though, as I just discussed, and as you all know well, inconsistencies are common among victims of trauma. And so what happened next was this back and forth where this police pressured Marie to recant her story. She did. And then she went back on it and said, no, I want to reinstate my claim. The police pressured her again, and again she recanted. And on that second recantation, the police filed false reporting charges against her. And what happened in this case is that the person who assaulted her went on to assault several other people in the next few years. Next slide, please. So this was an unusual case that's gotten a lot of attention because in this case, the police chief actually requested 2 full reviews of the investigation, and the result was that Marie was vindicated, that the detectives bullied her, hounded her, and coerced her into recanting her testimony. They ignored evidence that would have supported her report, and they focused on inconsistencies that were really not important in the general scheme of things, ignoring the symptomatology of trauma victims, of people who experience trauma in the course of that investigation by police. Next slide, please. And so I just want to wrap, I'm going to be moving to adultification bias, but before I do that, on false reporting, as you can see, as well as on the consequences of the crimes that are brought against the criminalization that's brought against gender-based violence that Ellie mentioned, this harm goes farther still than the harm to the individual. It creates distrust in the system, in police. It silences victims and discourages reporting by survivors. And it fails to hold perpetrators accountable, which in turn perpetuates the culture of rape myths and the acceptance of sexual assault itself. So that is a very weighty topic. And I just encourage you all to take a breath as we transition to talking about a related but different topic, which is adultification bias, which is one of the center's areas of expertise. I'm going to quickly define what it is and talk about the center's work on this before I turn it to Talia. Next slide, please. Just starting with what adultification bias is. It's a unique form of bias against Black girls. It involves racial bias, gender bias, and bias against young people. And it is the perception that young Black girls are older than the perception of white girls of the same age. So we tested how adults view Black girls and white girls and found that their assumptions about their age were discrepant, that Black girls were older than their age, whereas that wasn't true for white girls. Next slide, please. Here are some of the questions we asked participants just to show you how broad these questions were. We didn't show pictures of participants. We didn't describe scenarios or vignettes for them to respond to. Instead, we asked this simple question. One group got, do Black girls need to be supported? Do Black girls need to be nurtured? One group got the same question, but for white girls. And we split the answers up by age. So we asked, do Black girls under the age of 5 need to be supported? Do Black girls between 6 and 10 years of age need to be supported? And so on. And we hypothesized that the biggest discrepancy in how adults viewed the innocence and age of Black girls versus white girls would come in high school during the turbulent period of adolescence and puberty, etc. But what we found was different, and it was truly shocking. And I think it's why our report on this has really triggered a huge response and become part of the mainstream conversation, which we're really happy about. Next slide, please. This is a chart that represents what our findings were. It's oversimplified, but what we did was that white line at the bottom represents answers that participants gave held at a constant, so that the navy line, which reflects participants' answers about Black girls, can show the difference between them. So what this chart means is that the greatest discrepancy in adults' perception of Black girls' innocence came in the age group of 10 to 14 years old during middle school, at a time when we're all trying to figure out who we are, what the world expects of us, etc. And the second greatest discrepancy in perception of innocence came in the even earlier age group of 5 to 9 years of age. So that means we had participants answering that Black girls who might be kindergartners are less deserving and needing of protection and comforting than white girls of the same age. And there was also a discrepancy in the high school group, but less so than those two earlier age groups. And we really found this shocking, frankly, that this form of complex bias can be seen across the age groups of girlhood. And I'll turn it over to Talia to discuss the implications of the study.
Great. Thank you so much, Dave and Rebecca and Ellie. So I want to come back to two things. One, something that Dave shared at the very beginning, which was how do we contextualize and understand trauma? And he used the words of people and power. And I want to underscore that, but I want to add to that we have to think about this as system and power. And that the ways in which Rebecca is describing adultification bias, and then we'll jump in a little bit more fully, is about adultification bias as a form of structural trauma. So when we step back and we think about these different ways in which adultification bias is moving young people, in particular girls of color, Black girls, and women, back and forth, right, within systems, it's not only producing health inequalities and inequities, but it's producing psychological injury. And so when we think about structural trauma and the systemic and institutional ways in which we're producing and perpetuating marginalization, oppression, and violence, or to use Dave's words, culpability, constraint, and punishment, we really need to put it in that context. And you may be more familiar with structural trauma in the context of racial profiling, for example, right? Or discrimination more generally. And so we really want to make sure that this is part of the conversation. The other thing I want to underscore is what Rebecca said. With the case studies, as difficult, right, as it was for us to sit with those in such a brief time together, was that there's such disparities evidenced in the data. And while she didn't give us a full explication of the data, the ways in which this is manifesting for survivors, in particular then women of color and Black women and Black girls as survivors, again, puts us in this place of why should we be having a conversation about adultification bias, but more importantly, why should we be acting to mitigate, to reduce, right? And to really diminish those harmful effects in a compounding nature. Next slide, please. So as Rebecca mentioned, adultification bias is a complex form of bias, but we have to step back and say, where and how does this complexity start to interact, and how do we think about it in the context of law? So, how is adultification bias affecting, right, legal systems, but also legal actors? Now, this is about the people and the power, responding to Black girls' trauma. And that's where you must start with stereotypes. What are the stereotypes that play into adultification bias? What are the legal stories and narratives, to Ellie's conversation earlier, right, in her presentation? And so any basic framework, any floor before we move along is to understand this as intersectional. And this is a term that Professor Kimberly Crenshaw coined, and we've seen very much discussed both in the media and beyond. And she gave us this really important visual to think about how you're standing at an intersection and cars are hitting you from every direction, and how do you distinguish and differentiate the experience and harm that you're having in particular. Next slide, please. But adultification bias is not simply intersectional. It isn't just because of your identity, of your Blackness, your girlness, right, your womanness. It's sitting in a place of a combination of all, where age becomes an important element, right? And this is to Rebecca's conversation a moment ago, and really illuminating what the foundational study found. And there's certainly been other studies that have subsequently looked at adultification bias. Next slide. So where did these stereotypes emerge from? Why should we be concerned about these? And how do we dismantle them if we're thinking about people in power and legal systems and systems themselves? Well, first and foremost, they come from a historical era, right, passed down through legal narratives, through legal stories. And I use those words directly because all of case law, right, every single one of these moments about cases, whether Rebecca's referring to a circuit court decision or Ellie's thinking in the state courts. It's all passed down generationally, written down in law. And the stereotypes that have followed Black women and girls in particular are two that show up in the context of adultification bias. One is a hypersexualization. And the other is an angriness, right? So the Jezebel and the Sapphire, you see that we have reference here, and that those that increase the likelihood in which someone then is perceived as disrespectful, inappropriately sexual, right? At a very early age in particular, aggressive and threatening, and then those become the consistent narratives and through lines in both an implicit and often explicit way. But adultification bias is so pernicious and dangerous because it is an implicit bias, as we think about in the next slide. This is where we might want to just take a moment and internally pause, a moment of interoception. And if you hit the slide again, I think it'll bring up the pause and reflection question. And sort of ask yourself, in your experience, have you seen, have you felt, have you witnessed stereotypes showing up in the ways that we might be referencing here in our brief time together and are harmful to Black girls? You are welcome to use the chat function, but you also might just want to think about this internally, sort of reflecting in that way. Both of those will be available. And I'm going to pause then, right? Because we can't pause and reflect if I continue to talk. So maybe you were like me and you had things bubble up. Maybe you were like me and you picked up a pen and you wrote something down. Maybe you just sort of sat with it in that way. But again, starting to link the earlier through lines, starting with Dave, all the way through what Ellie explained for us and emphasized how law has power over survivors, where Rebecca's brought us to some really concrete ways across this continuum about how is this not just ignoring, but also perpetuating and producing uniquely trauma because of adultification bias. Next slide. So we do want to be clear, right, that there are tangible legal consequences for Black girls who experience trauma, and that comes directly back to the perceptions about them, right? So whether that's a victim blaming ideology, or that's because they don't need as much care and sympathy, this is what is driving then the ways in which Black girls, both individually and then intergenerationally, as they move into womanhood, experience the legal system. And so it's at a core, right, where we understand that adultification bias is contributing to the failure of the legal system to weigh the innocence of Black girls who are experiencing trauma or the effect on trauma. And that's not just about perpetuating the stereotypes, right? It's really about how and where our systems are exerting power over people and policing and punishing them in ways that are not just disproportionate, but deeply harmful and compounding. Next slide. We want to bring us, I want to bring, and we want to bring everyone to a place also of intersection here with adultification bias and anger bias. And this is where we can think about a compounding effect, that adultification bias can be compounded or exacerbated by anger bias, meaning, right, that the perception of Black girls as being angry, right, is not because they're angry, it's because they're in fact exhibiting trauma symptomology. Right? And so how and where, next slide, that then can show up is looking at some of the newest research around anger bias. So when you're perceiving a child to be older than she is, then your odds of that anger bias actually increases by 4% for every year you have an increased perception of age. And that was uniquely to Black children and not to white peers. And so I really appreciate, right, the right-hand side of this slide is that we're moving through a continuum. Adultification bias sits there every day in the background, every one of our legal systems, and then anger bias compounds, and then we have a misinterpretation of trauma as symptoms and threat. Next slide. I'm just going to point these out because we'll come back to them when you have time, right? When this is sent out, but certainly there's been studies, this one is in New York, about facilities and staffs making judgments about disciplinary actions that are clearly indicative of trauma and victimization, right? Whether that's being trafficked or at risk or running away. Next slide. The second thing that I really invite everyone to come back to was to think about entry into the system, our pathways for our youngest girls in particular, right, that are entering from sexually abusive or unstable environments, and that their trauma is dismissed and not believed. And I think it's really important to take the airtime to remind everybody that, and this is why the quote is there, that they're viewed as criers, as liars and manipulator, young children, right? Young Black girls, and that they weren't in need of support. And in fact, you see an example from a case file here with a pathologizing about victors of crime. And as Rebecca talked before, the victim blaming ideology. Next slide. But pathways to entry aren't just simply about from external environments such as the home or in community. It's very much linked to school. And so how we think about the school to prison pipeline, both individually but intergenerationally and compounding, becomes so significant for the way in which our legal actors respond. Black girls are at the greatest risk of being arrested in school. And because of that, right, it means that they are entering into our criminal legal system, starting to experience not just adultification bias at the school level, but then also the structural trauma as exists within the legal context as well. Next slide. And it's not that Black girls are being arrested in schools for acts of violence, right, or for objective offenses. It's disproportionately for subjective offenses. Poor attitude, willful defiance, failing to comply, right? A whole host of things, disrupting the classroom. So those stereotypes that are so embedded, right, those become centralized in this context. Next slide. And just click one more time. This is also something that I want to leave everyone with to come back to when the slides are shared out, which is we can't give enough time and treatment in 5 minutes in a totality of a conversation to maybe really all pause and reflect and think about adultification bias causing inequities in treatment. For Black girls who've experienced trauma, or the ways in which adultification bias is in itself producing trauma. And because each of you come to this with your own set of experiences, right, you will be thinking about this through that filter and lens. I'm actually going to pause and ask Rebecca a question, which is to say we have 5 minutes left, and Dave had promised that we might have some conversation amongst all of us. But I also know that we've included some taking actions and some solutions because that's so important relative to the work of the center and for each of us sitting in this group. So do you have a preference if we just pause and take the last 4 for that, or would you prefer that we go through some of the solutions?
I'm gonna split the baby on this one. Dave, could you forward the slides?
Yes, just forward them to participants here in the group.
Oh, no, I just meant move to the
forward.
next slide, a couple, but that's
Yes,
okay. If you don't have it up, we don't need it. I was just gonna show the slide that gave the broadest buckets of
35 maybe?
our choices. Yeah, so just keep clicking. Click. Yep, there we go. That
Cool.
last one. Yeah. So these are the biggest buckets of solutions that we usually talk about in more detail with more time about training, collaborating with colleagues, creating accountability around bias, and gathering stories and data in order to best evaluate whether adultification bias is showing up in your system. So why don't we just conclude there? We just have a few minutes for questions.
Hi, thank you so much, all 3 of you, for that. I want to ask if this unfair and horrendous treatment of women, and especially Black girls and women, goes back to slavery and men's attitudes towards this commodity.
Yes, we all nodded as you said that, Lisa, because those stereotypes certainly emerged within a slave context and then even in a sort of post-slavery and Reconstruction, not just at the individual level, but in law, those stereotypes are written into case decisions, and especially as there were tensions as Black women and Black girls were trying to seek their freedom through manumission suits, that was coming up as a justification to continue to hold them, even in the absence of slavery, in a form of slavery as well. So the sense of ownership.
And if you're not familiar, you probably are, but with Brian Stevenson, he's in Montgomery, Alabama. He runs the Equal Justice Initiative. Just Mercy, the book and movie are his. But he does a lot of work on this issue and the overlap between our criminal legal system and slavery. And he always says when slavery ended, like it didn't really end, it just changed hands to the criminal legal system, is really how he describes it. But he does a lot of excellent work on that topic that might be interesting to read for anybody interested.
Well, maybe what's helpful is if we all put our contact information in the chat. I know that it's in the slide deck, but that might not come to everyone right away. And I just want to say thank you to Dave for hosting us, and to my colleagues. It's always a pleasure to join with you, and we could have this conversation for a very long time.
Yeah, I echo those same thoughts. I just put my address into the chat, and we really appreciate your showing up today and for our presentation being a little bit speedier than usual. We still hope that you got a lot out of it.
Thank you all so much. Yeah, I feel like I wish we had another half an hour or two. But I have a feeling the conversation that you started here is going to continue to resonate, as I'm sure it often does in your presentations, and we'll pay attention to that in our community as well, and hopefully get to reflect some of that back too, and stay in conversation as time goes on. We're grateful for you, all of you, for your work, for your presence here, and thank you so much. Thanks everybody also for taking time out of your day to be here.
Thank you.
Thank you.
Take care, everybody.